Good morning, everyone. Thank you for joining us today uh, in this workshop on ethical and legal guidelines in data sharing. My name is Hina, and I'm a senior research data officer. Um, and I'm based in the research data management team at UK Data Archive, and we are based in the University of Essex. And my colleague Gail is also with us to keep an eye on the technical side of things. So before we start, if you could go to menti.com, you can use this code for a quick activity. This will give us a little bit of time so that some more people can join before we formally begin our workshop. You can use this QR code from the camera of your mobile, and I would be using Mentimeter throughout the workshop. So you can keep it open. It's just a general question to help us inform to plan or plan content for our next session. We do run these workshops twice a year. So is there any specific aspect of ethics and legal compliance that you are particularly interested in? Because I may have added some content that is not relevant for you, or there is some content that I have not added and it should be added. So I'll add it for our next workshop. Okay, so there isn't any specific aspect so far. So data governance, consent for data sharing. We do have a consent dedicated workshop on consent for data sharing coming up. You can check that. I don't have the date in my mind, but I think it's in the coming 2 weeks. You can check that and register for that on our event page. So ethic approval for public figures on social media platforms, data protection for personal and sensitive data for human participants, sensitive data, personal data related to individuals and their workplaces. Okay. I'm a PhD student and would work with secondary data. I would like to know the ethics and legal compliance involved. I will touch upon a little bit on secondary data and copyright issues related to that in today's workshop, but we have dedicated workshop coming up, I think either this month or next month. You can check it on our events page, which is about copyright and publishing, copyright and secondary data use. So that's another one to register if you are interested. Sharing data between council departments and between local and central government, secondary data. Yeah, okay. Protection of data from AI. We haven't started including AI, but it's in the pipeline because that's, I think, the most needed one now, the ethics related to AI. So certainly we will add it. Thank you very much for your responses. And if you plan to share your data, how confident do you feel in terms of ethical and legal compliance? Likely, yeah, it's a tricky one, I think. So someone is very confident, so that is very good. And most of you are somewhat confident, and I hope so that after attending today's workshop and some of our upcoming workshops related to ethics, legal compliance, copyright, consent issues, and documentation, and there is another one coming up on anonymization. So there are some to come that may be useful for you. I'm hopeful that you will find them useful and you will be more confident. Thank you very much. Thank you, Gail. Gail has added the links to these in the chat for our upcoming workshops. Thank you very much for your responses. That's really much appreciated. So coming back to our workshop, the overall aim of this session is to show you the key considerations in primary and secondary data sharing. The first section focuses on the key principles of ethical research set out by ESRC, which is then followed by the next section on legal frameworks that govern research data. And we will also be covering the role of consent, but very briefly. As I said, we have a dedicated workshop coming up on consent. So finally, I will talk you through to the key considerations in secondary data use, and I will answer your questions in the end if we have time left. Otherwise, I have created a Padlet. Gail will add the link to the Padlet in the chat. You are very welcome to add your questions throughout the workshop. And I will keep the Padlet open for 48 hours. Any questions that you may have, you are welcome to add it. I will answer the questions there, and I have provided my email address or shared mailbox address on the last slides. So if you have any specific project related queries, you are more than welcome to email us, and we are happy to help you in for those specific project related queries. And I'm always happy to have a Zoom call as well to go through if that's you find more convenient. So I hope you are aware that research data is of two types, primary data and secondary data. Primary data is the data that is collected by a researcher directly from the original source through experiments, surveys, interviews, observations, or focus groups. And on the other hand, secondary data is an existing data that is gathered from studies, surveys, or experiments. And but it has been run by other people or for other research purposes, such as existing data sets at archives, essays, reviews, social media data. So this has been done by someone else and maybe used later on. So this is called secondary data. So the first section is related to primary data. And I will briefly discuss the key principles of research ethics, and I will also talk you through to some of the ethical considerations and best practices in data sharing, including research ethics self-assessment tool by UKSA in this section. So before we go to this section, there is a quick question on Mentimeter for you. So this is the code, and this is the QR code if you would like to scan it. Yeah, those who joined us later, you can keep the Mentimeter open on your mobile phone because I will be using it throughout the workshop. So what do you think are your ethical obligations as a researcher when sharing your data for future reuse? So please bear in mind I'm asking about the ethical obligations in the context of data sharing, not a standard ethical obligation as a researcher. Yep, transparency, that's great. Sharing data with participants' permission, yes. Consent, yeah. Confidentiality and consent, having appropriate consent and having informed the patient correctly. Yes, that is important. Mm. Yeah, if you have any questions, please add it to the Padlet because I won't be going through the chat after the workshop or at the end of the workshop to look for the questions. I will only go through the Padlet because that is more convenient and time saving instead of going through all the chat. You can use the chat function for any technical issues or any general queries, but for the questions related to the content, please add it on the Padlet. So there are many responses. Thank you very much. That's amazing. Anonymization, yes. GDPR, research integrity principles, Creative Commons licensing, making data fair. Yeah. I did a workshop, I think it was two weeks ago. You can check the slides and the recording on the YouTube channel, and it was around a recap of effective and practical research data management, and it did include fair and care principles as well in there. So data sharing, ensuring where you are sharing is appropriate and consistent with where you have said you will share it. That's right. So yeah, majority of you think that it should be an informed consent around data sharing, providing the relevant information is the most important thing to the participants. Yes, that is absolutely right. Thank you very much for your responses. So in terms of the ethics, ethics issues are most likely to arise around privacy, equality, diversity, and health and safety, as most of you have mentioned there, confidentiality and so on. So research ethics govern the standards of conduct for scientific research, and it is important to adhere to ethical principles in order to protect the dignity, rights, and welfare of research participants. ESRC, Economic, Social, and Research Council, has set out key principles for ethical research. For example, researchers should ensure that their research is beneficial to participants, individuals, science, and society, and they should be realistic about the benefits that it is likely to deliver. And research should be designed and conducted in a way that respects the rights, interests, values, dignity, and autonomy of the participants. And researchers should inform participants that they have a right to refuse to participate, and it is free of consequences, and they can withdraw from the research for any reason. Yeah, and integrity demands that there is a clear fit between what researchers say they will do and how they will conduct their research. While transparency means being clear about the nature of the research and communicating this to those involved, as some of you have mentioned on the Mentimeter. Researchers must exercise self-critical responsibility in the planning and conduct of their research, and research ethic committees and research organizations have a responsibility to guide and support researchers, especially when the research involves difficult ethical decisions. And researchers should maintain the independence of their research, and where conflicts of interest cannot be avoided, they should be made explicit. And independence of research is founded on academic credentials, professional standards, expertise, and experience, and it should be always free from personal, organizational, and political bias, dishonesty, and considerations of gain should be safeguarded at all times. And you should be providing information about the future uses of the data that is being collected. And in the context of data sharing, this is also very, very important. So it is important that researchers do not just consider what can be done with the data, methods, expertise, and technology available to them. It is equally important that researchers consider what should be done. And National Statisticians Data Ethics Advisory Committee provide a framework to help all researchers to think about the ethics of their research at an early stage and give them confidence that their plans address ethical principles and practices. So they have designed a very useful ethics self-assessment tool to review the ethics of the project to be undertaken. And this tool enables to identify and mitigate any ethical issues. And I have added a link on the slide, and it is beyond the scope of this workshop to go into the details, but I would ask you to have a look at it. It is a very useful tool. So just to give you a bit of information, um, it is based on 6 main principles: uh, public good, confidentiality, methods, legal compliance, public views and engagement, and transparency. And you are asked to assess your project against 22 items grouped against these 6 ethical principles on a scale. So I found it really useful, so you can have a look at it later on. Someone has written that please share the link from the previous slide. Um, it is difficult for me to share the link. It's, yeah, you can email me and I will share the link through an email after the workshop. Because I'm not very technical person. I can't multitask copying link, opening the web page, copy it from there and put it in the chat. So someone has already added a link. Thank you so much. So, but Gail is going to add these slides on our events page, and from the link, you can get all those links that I have inserted on the slides from our event page. So there is another useful resource called Data Ethics Framework by the UK government. I also like this one as it provides guidance on the appropriate and responsible data use in government and the wider public sector. It helps to understand ethical considerations and address these within the project. You can use this. And I think I have opened it this morning, so I can show you this one. So that's a really good guide. So this is the data ethics framework, and they have provided the information around what is it for, who is it for, how to use it, and the structure of it. So this framework, I think it consists of overarching principles and specific actions that covers the entire process of a project, and each section include questions that will guide you through ethical considerations for your project. And as I said, it is quite useful. So these are the principles: transparency, accountability, fairness, and you can score it. So I have added a link on the slide, and that's also a very good one. So ethical obligations should be considered at very early stage of the research life cycle, almost from the beginning, from planning and data collection to analysis, sharing, and publication, all towards the end. Researchers have a responsibility to be fully aware of and adhere to these ethical policies and guidelines set by their institutions and other relevant research organizations. So it is also essential to comply with all applicable laws and regulations, particularly those related to data protection, privacy, and intellectual property. And throughout the research process, care must be taken to avoid causing any form of social or personal harm to participants. communities, or any other stakeholders. So, when dealing with data, researchers should communicate with data repositories or ethic committees to seek appropriate guidance on data handling and sharing. So, as I said, you can always email us and at any stage of your research, and we are happy to advise on any aspect or any query you have related to data sharing. So, obtaining informed consent that includes permission for possible future uses of the data is also crucial, as some of you have mentioned on the Menti. So, yeah, it is to ensure transparency and respecting participants' rights and upholding ethical integrity um, in research practices. So that is quite crucial when it comes to data sharing. This section is all about legal frameworks that govern research data. In the context of data sharing, it would be easier to talk you through about the legal frameworks governing research data if I take a broader classification of research data by Health Research Authority. According to them, data used in research can generally be categorized into three main types based on the level of identification and privacy protection. So, first, there is a data that relates to identified or identifiable individuals, which means that information that can directly or indirectly reveal a person's identity, such as names, addresses, ID numbers, or even combinations of data that make someone identifiable. Uh, I always have problem in pronouncing these terms, so apologies for that. Uh, this type of data requires strict ethical and legal safeguards to protect individuals' privacy and comply with data protection laws. And then there is the second type, which is anonymous data, which has been processed in a way that individuals can no longer be identified. And in this form, all personal identifiers are removed and the data cannot reasonably be traced back to any individual. So, anonymous data is often used to minimize privacy risks while still enabling valuable research. And the third type is synthetic data, which is artificially generated data that mimics the structure and statistical properties of real data but does not correspond to actual individuals. And it is increasingly used in research and data analysis because it allows researchers to test models, share their data sets, and develop insights without exposing sensitive personal information. So, together, these categories illustrate the varying levels of privacy protection and ethical considerations involved in handling different types of data. And I'll go through each of these briefly, and also the legal frameworks that govern these. So, the first type is, as you can see here, is about the data that relates to identified or identifiable individuals. But before that, just a quick intro to the personal information or data, because there may be some people who doesn't have any clear idea what is included in the personal information and what is not. So you can identify an individual through personal information about a person. And as I said earlier, people can be identified directly or indirectly. And examples of direct identifiers are name, address, postcode, telephone number, voice, picture. And some of the examples of indirect identifiers are occupation, geography, unique or exceptional values in the data, which when combined can identify a person. So personal data also includes special category data that needs more protection because it is sensitive. And UK GDPR defines special category data as personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, genetic data, biometric data, or health data, sexual orientation, all of these things. So most health research uses special categories of personal data. Um, and if personal information about people is collected or used in research, data protection regulations apply. So that is the important bit. So coming back to the first type of data, which is the data that relates to identified or identifiable individuals, there are two main legal frameworks that relates to identified or identifiable individuals: the common law or duty of confidentiality and data protection legislation. So in the UK, there is a duty of confidentiality that is based in common law, and that occurs where confidential information comes to the knowledge of a person in circumstances where it would be unfair if it were then to be disclosed to others. And there are some exceptions when you can disclose information. For example, if participant consents to onward sharing of their personal data, then sharing does not breach duty of confidentiality. And under this law, you will need to obtain an explicit consent if confidential information is used uh, for a research project. And this should be very clear and specific statement of consent, and it can be given in writing, verbally, or through any other form of communication. Um, yeah, so any other form of communication could be a sign language. So sometimes public interest can also override duty of confidentiality. And occasionally there are instances when you may need to give up data, such as on a court order. So the best practice is to avoid very specific promises in consent forms. We will go through these in more detail in my dedicated workshop on consent issues, which is, I think, in 2 weeks' time. So, as researchers, we must adhere to data protection requirements when managing or sharing personal data. So, if personal information about people is collected or used in research, then the data protection regulation applies. And data protection legislations that are most widely applicable to the research are Data Protection Act and the UK GDPR, and I would say EU GDPR here as well. So it is therefore important for researchers to ensure that they gain local support from their university data protection officer when their research project will span across the EU. Um, in case if the researcher is based in the UK and they collect personal data about people anywhere in the world, or a researcher outside the UK collect personal data on UK citizens, then DPA and UK GDPR both applies. However, if the researchers are undertaking research projects which span across the EU, then the EU GDPR will also need to be considered and adhered to. So it all depends. It's a good practice to uh, consult your organization data protection officer. So the UK GDPR specifies the rights a data subject has when their personal data are processed. Individuals have several key rights under data protection laws that ensure their personal information is handled responsibly and transparently. For example, the right to be informed. It means individuals must be clearly told how their data is collected, used, stored, and shared. Usually, this could be done through privacy notices or consent forms. Then they have a right of access, which allows individuals to request and obtain copies of their personal data held by an organization, helping them understand how their information is being used. And they also have a right to rectification, which gives individuals the ability to have inaccurate or incomplete data corrected, ensuring the information remains accurate and up to date. And then there is a right to erasure, often called the right to be forgotten, which allows individuals to request their personal data be deleted when it is no longer needed or if they withdraw consent. And the right to restrict processing enables individuals to limit how their data is used. For example, while accuracy is being verified or during the disputes. So the right to data portability allows individuals to receive their personal data in a structured, commonly used format and transfer it to another organization if they wish, or even to another country. And finally, the right to object gives individuals the power to stop their data from being processed in certain circumstances, such as for direct marketing or profiling. So, together, these rights empower individuals to maintain control of their personal data and promote accountability and fairness in data handling practices. Everyone responsible for using personal data has to follow strict rules, which are called data protection principles. For example, it should be processed lawfully, fairly, and transparently, which means that data collection and use must comply with legal requirements. It should treat individuals fairly and clearly communicating how their data will be used. And data must also be kept to the original purpose for which it was collected, ensuring it is not used for unrelated or any unauthorized activities. And it should be minimized, meaning only the personal data necessary to achieve the research purpose is collected, avoiding any unnecessary or excessive data gathering. So once data is no longer required, it must be removed if not necessary, preventing unnecessary storage or misuse. And the accuracy of data must be upheld so that information remains correct and reliable throughout its use. And finally, all data should be kept confidential and its integrity maintained, protecting it from unauthorized access, alteration, or any loss. And these principles, they form the foundation of good data management and help maintain trust, legality, and ethical standards in research and data processing. So, under the UK GDPR, there are 6 possible grounds for processing personal data, and one of these must be present. Under the UK GDPR, organizations must have a lawful basis for collecting and processing personal data. This means that data can only be used when there is a clear and valid legal reason. And these 6 lawful bases, they are the first one is the consent, where an individual has freely given clear permission for their data to be processed for a specific purpose. Second one is the contract, which applies when processing is necessary to fulfill a contract with the individual or to take steps before entering into one. The third one is legal obligation. So where processing is required to comply with the law, such as maintaining employment records or reporting financial information. Then vital interest, which applies when processing is necessary to protect someone's life or safety. And public task also allows data processing that is necessary for performing a task carried out in the public interest or in the exercise of official authority. And legitimate interest, it applies when processing is necessary for an organization or a party's legitimate purpose, provided it does not override the individual rights and freedoms. So selecting the correct lawful base is essential for ensuring compliance, transparency, and trust in how personal data is handled. So there is a quick question on the Mentimeter around this. If you could please go to the Mentimeter again. I'm not sure if you have ever used any legal base to process personal data, but if you have used or you intend to use, which legal bases have you used or intend to use for your research? Any idea, any thoughts? I know some of you are PhD students, and when I was doing my PhD, I wasn't aware with all of this. So don't assume that you are aware that what legal basis you have been using or intend to use. Yeah, there is a comment in the chat that public task is the most common. Yeah, that's right. So it's a Miss Helsinki. That's interesting. GDPR, legitimate interest, public interest, national laws, special category data. Yeah, thank you very much. No more responses. No, there is consent. That's interesting. So public interest is, I think, the most commonly used here. Thank you very much for your responses. Oh, I skipped this. Anyway, this information was there on the Mentimeter. So, yeah, as you said, in the UK, the lawful basis for processing personal data in research depends on the type of organization conducting the study. For public bodies, such as NHS, health and social care organizations, universities, and UK research and innovation, the lawful basis is usually the performance of a task carried out in the public interest. So, yes, public interest. This means that their research activities serve a wider societal or scientific purpose that benefits the public. And for non public bodies such as charities, private research institutions, or commercial companies, the lawful basis typically relies on legitimate interests, which means that research serves a valid business or organizational purpose that does not override individual rights. However, when the research involves special category data, such as information about health, race, ethnicity, political opinion, or genetic data, additional safeguards are also required. And in these cases, researchers must not only establish a lawful base for processing it, but also identify an additional condition under the UK GDPR that justifies the use of sensitive data. Um, it could be processing for scientific research purposes with appropriate protection in place. And data protection impact assessment must be completed for any research activity that poses a high risk to individuals' rights or privacy. And this DPIA helps identify, assess, and mitigate potential risks before data processing begins. And it also ensures compliance with ethical and legal standards while maintaining public trust in research practices. So there is a misconception that data protection laws such as GDPR prohibits data sharing. However, it does not prevent data sharing as long as you approach it in a sensible and proportionate way. GDPR is useful for research as it legalizes much of the current good practice in research, placing people at the center. And it establishes a framework for responsible data handling in research and other activities, and it built around several key elements. At its core, the principles of data protection that we have gone through, which require that personal data be processed lawfully, fairly, and transparently, kept accurate, secure, and used only for specified purposes. And alongside these principles are the rights of the data subjects, ensuring that individuals can access, correct, request deletion of their personal data, as well as object to certain types of processing. And organizations must also identify a valid processing ground for personal data, such as consent, public interest, legitimate interest, and so on. A strong emphasis on transparency is required, which means individual must be provided with clear information about how their data will be collected, used, and stored. And clear documentation should be maintained to demonstrate compliance. And GDPR also allows the reuse of personal data for research purposes, provided that appropriate safeguards are in place. And in a way, it enables valuable research while upholding ethical and legal standards. So, yeah, it is, I think, very useful in the context of research, and it does not prohibit data sharing. So the second type of the data was anonymous data that no longer relates to identified or identifiable people. This is just to remind you, this is this classification that I'm following by the Health Research Authority. So their second type is about the data that can be identified or identifiable. So this is the data that has been anonymized or pseudonymized. Personal data that has undergone effective anonymization is not regarded as personal data, and therefore it is not subject to the UK GDPR. This is because the data has been modified and transferred or otherwise made available to another organization such that it no longer relates to an identified or identifiable individual. And there are several anonymization techniques that can be used, for example, aggregating, suppression, rounding, reduction in detail, addition of noise, and so on. But it is beyond the scope of today's session to talk you through these. But as I said, we have an anonymization workshop coming up. I think it's in November, where my colleague who has expertise in qualitative data, she's conducting that workshop. So you can sign for that. And then there are some links on the bottom of the slide for you to have a look at later for further information around anonymization. So the data that is treated in this way is no longer considered confidential and generally speaking does not fall within data protection laws. It is important to note that even when data is anonymized, it may still be possible to find ways of identifying the individual. However, it would likely require special circumstances or effort. This effort may involve using other sources of information to narrow down the number of individuals that the data may be referring to. So, but this is just a debate whether anonymization can be effective or not. So that is another debate, and I think you might find useful information in that workshop that my colleague is going to run in November on anonymization. On the other hand, pseudonymization is a security enhancing process that replaces or removes information in a data set that directly identifies an individual. And it is typically applied before information is shared with a third party. For example, it could involve replacing an NHS number, a name, or an address with a unique number or code, which is usually called pseudonym, with the effect that identifying an individual directly from their data is not possible by the recipient without additional information, which is usually the key that would enable matching the pseudonym to direct identifiers in the data. So personal data that has undergone pseudonymization but could still be attributed to an identifiable individual by the use of data alone or in combination with other data likely to be available is legally presumed to remain personal data under the UK GDPR. So that is the difference. Effective anonymization is not subject to UK GDPR, while pseudonymization could be subject to the UK GDPR. So the third type is the synthetic data, which is artificially created rather than generated by real world events. And it can simulate synthetic populations that resemble the characteristics as well as diversity of actual people. It can also be generated to be statistically consistent with a real data set, which it may then replace or augment. So synthetic data is neither personal data nor confidential patient information is in there. So it is not subject to data protection legislation or the common law confidentiality because it is artificially created rather than generated by real world events. There is a synthetic data that is being created from the real data. I'm not talking about that sort of data. It's data protection legislation does not apply on the data that is created artificially. So there is a quick activity on the Mentimeter. Thank you, Gail, for adding a link to the anonymization workshop in the chat. This is the code for the Mentimeter. You might have remembered it's just after the last slide, this question. Effectively, anonymized data is not subject to the UK GDPR. Most of you have said yes. So yeah, it is a true statement that effectively anonymized data is not subject to the UK GDPR, but there is a debate how much effective or if there is any chance of identifiability. I would say that the term effective does convey that there is no chance of disclosure or identifiability risk. So yes, that's true. Thank you very much. So what do you think? If the researcher based in the UK collects data from the EU, which of the following applies? Yes, that's right. Both UK GDPR and EU GDPR both applies. Thank you very much. Yeah, I think that's it for now. Let's get back to the presentation. Yeah, so this section focuses on the role of consent in research, but it's very brief. I will cover it in detail in my upcoming workshop on consent issues. So I'm sure you all are familiar with what informed consent is. However, when it comes to data sharing, then consent is used for two purposes, to fulfill ethical obligations and also to be legally compliant. We are all familiar with what consent is, which is used for research participation and is considered as one of the founding principles of research ethics, where it is sought before participation in any research activity and for all participants. And it usually involves providing information regarding study purpose, risk, benefits, participation, and so on. However, as stated earlier, consent can be used as one of the legal bases of processing personal data under the UK GDPR. So if a researcher collects, manages, and shares personal data, then consent of the data subject can be used as a lawful base to process this personal information. But as mentioned earlier, in the UK, it is rarely used as a lawful base in research context. As some of you have mentioned, we use public task. Though not mandatory under the UK GDPR, but you need to obtain an explicit consent under common law duty of confidentiality when you have to disclose or share confidential information for research purpose. Uh, Therefore, consent plays a vital role to be legally compliant, specifically when it comes to being transparent, fair, and maintaining confidentiality. And it can be gained in written or oral form. The format depends on the kind of research, but it is important that whatever format is used, written or verbal, it should be documented. You need to document how it has been gained, what information has been provided to the participants, and what they have agreed to. When designing consent forms and information sheets for research, the wording should be carefully structured to cover three key areas that help participants make informed decisions. So the first area is taking part in the study, where you should clearly explain what participation involves, including the purpose of the research activities, procedure that they will undergo, the time commitment required, any potential risks or benefits. In the second area, which is around use of information in the study, it should detail how the data collected will be used, analyzed, and reported, including any assurances about confidentiality, security, who have access to the data, and so on. While the third section should be around future use and reuse of the information by others. And it should inform participants about whether their data might be shared with other researchers, stored for future studies, or used in ways beyond the current project. And it should specify the safeguards in place to protect privacy and comply with ethical and legal standards. And I think by addressing these three areas clearly in the consent forms, researchers can ensure that consent is truly informed, transparent, and ethically sound. So it's an easy way to divide it into three areas. And if you plan to share your research data, this third one, future use and reuse of the information by others, is really, really important. When you start a research project that involves collecting information from people, for example, through a survey, interview, focus group, video recording, then these questions can help you to comply with data protection legislation in practice. The first consideration should be whether the project needs to collect information that would be defined as personal data. Is it necessary? If not, then do not collect it. If the research does not collect personal data, then data protection legislation will not apply. If personal data are being collected, the researcher needs to identify who will be the data controller for the collection, storage, and handling of the data. This is unlikely to be the researcher themselves, and in most instances will be the researcher's university or institute. If the research involves collaborations of different partners, it will be important to identify whether they will be joint controllers of the data or data processors. It will be crucial to ensure data sharing agreements should be in place, and where necessary, a processor controller agreement as well. Data controller is actually the person who determines the purpose for which and the way in which personal data is processed. By contrast, data processor is anyone who processes personal data on behalf of the data controller. To give you an example, if you deposit data with us, you are the controller and we are the processor. We process it on your behalf. So we are the data processors. Then an assessment will also need to be made about the most appropriate processing ground to use for each research project. And as we have seen that there are three grounds that appear most applicable for research, that were consent, public task, or legitimate interest. So you need to identify the most appropriate one. And if you are using consent as the processing ground, it is crucial that this is distinguished from consent for other ethical and legal purposes, and that participants can withdraw their consent for processing personal data if they want to. And if public task is used as the processing ground, you must ensure that your university or institute is classified as a public authority and that the research will be in the public interest. And if you are using legitimate interest as a processing ground, then a legitimate interest assessment should be undertaken. And yeah, you need to do this. The information that needs communicating will be influenced by which processing ground is chosen. So broadly, participants should be informed about how any personal data collected about them will be used, stored, processed, transferred, and as I said, who the data controller is, who the data processor is, legal grounds, every information should be communicated to them. So, despite all the information I have gone through, bear in mind that much research data, even sensitive data, can be shared ethically and legally if researchers employ certain strategies that protects privacy and privacy of the participants while enabling research and analysis. And one key strategy is the protection of identities when promised, often achieved through techniques such as anonymization or pseudonymization, which ensure that individuals cannot be directly identified from the shared data. And another important consideration is establishing a valid processing ground for personal data. So, and the third one is access to the data should be managed according to its sensitivity, using regulated access mechanisms where necessary. And this could be open access, safeguarded access with certain restrictions, or controlled access for highly sensitive information. And this, together with these strategies, you can balance the goals of data sharing and transparency with the obligation to protect individuals' privacy and maintain trust. So just relevant to, I have just mentioned the access levels. So by regulating access levels, data sharing especially, it facilitates data sharing. When it is not possible to anonymize data or to obtain consent, then it can facilitate data sharing. In that case, you can restrict user access. For example, here at UKDS, we facilitate 3 levels of access for data. Open access for the data that contain no personal information, or if there is personal information, the consent is in place. Then there is safeguarded access for the data that contain no personal information, but the data owner considers a risk of disclosure resulting from linkage to other data, or it is available under our end user license and users need to register to access data. And controlled access is for the data that may be disclosive. And it is only available to users who have been trained and accredited, and their data usage has been approved by the relevant data access committees. So managing access to the data always facilitate and help data sharing. So this is, I think, the last activity, maybe on the Mentimeter. There is a question in the chat. It would be helpful if you could add this question to the Padlet, please, because I don't think so that we have time to go through the questions at the end. I will answer the questions on the Padlet, and you can, after the workshop, and you can see the answers to your questions. So if you please could go to the Mentimeter. So there are some questions related to the consent here, just to reinforce what I have been talking you through. So what do you think informing participants about the future uses of data is an ethical obligation, a legal obligation, or it depends? Yeah, I think it's a tricky one. It could be an ethical obligation if you are not using consent as a lawful base, then it is an ethical obligation. If you are using consent as a lawful basis, then it is a legal obligation. So I think it depends. Thank you very much. So this is a statement in the consent form. So do you think it is appropriate if you add these sort of statement in the consent form? In the context of data sharing, bear in mind. Any information I give will be used for research only and will not be used for any other purpose. Yeah, I think this is, if you plan to share your research data and you have used a consent form that has this type of statement in there, then these kind of statements prohibit data sharing. So if you are required by your funder to deposit data for future reuse, then this is a problematic statement. If you do not plan to share data, then it's not a problem for them. So it depends on the context, I think, and your intention, whether you plan to share it or not. Then we do come across these type of statements as well when we review data deposits and documentation. I understand that only the research team will have access to the data I will provide. Do you think it will help or it will prohibit? Again, it depends on the intentions. If you are planning to share your data and you want to deposit it in an archive or a repository, then it will prohibit data sharing. And usually the way forward is to seek retrospective consent. I will go through these in more details and we will examine the real consent form statements in my workshop on consent issues. So yes, this type of statements do prohibit data sharing. So you should be very careful in using wording in your consent form if you plan to share your data. Thank you very much. And then there is another one, although we haven't gone through this, and we will go through this in my next workshop, but just, yeah. So such specific promises should be avoided. You need to adhere to your organizational policies, and this is a vague statement as well. It says all research data will be destroyed after 5 years, 10 years. So yeah, usually the standard consent form templates that are used in organization, they do say that personal research data will be destroyed. For example, consent forms, completed consent forms, and any personal information that is not relevant for the purpose of the research, this will be destroyed. So that should be okay. But saying all research data will be destroyed, that prohibits data sharing. Thank you very much. Let's get back. Okay, the final section is about what needs to be considered if you are planning to use secondary data sources. As I said in the beginning, that we do have a dedicated copyright workshop. I think you can register for it on our events page. So we will go into detail in that workshop. It's just to give you a bit of brief intro. So two most relevant types of rights applicable to the research secondary data sources are copyrights and database rights. And I'll just talk you through to the copyright ones, which is most important due to the time constraints. But I have added a link at the bottom for the other rights for you to have a look at later. So copyright or IP rights are assigned automatically to the creator or the researcher who owns the data. When data are shared or archived, the original owner retains the right, and data archives or repositories cannot archive data unless all right holders are identified and give permission for their data to be shared. And copyright applies as soon as the data is created. You are the copyright owner of the data that you share for future use by other researchers. And in the context of primary data, if you plan to share it for future reuse, you need to consider how you want your data to be used by other researchers or students. And you can specify this by licensing the data to match the intended uses. And various type of licenses for sharing data have been developed by the data archives. As I showed you the 3 access levels, and then there are some licenses that are bespoke ones that we do offer. So in the UK, copyright arises automatically once a work is created, and to enjoy copyright protection, the work must be original. That is to say, it must be your own work, not copied from someone else. And there is no copyright in ideas or facts, only in the way those ideas are expressed, such as diagrams and tables and so on. And as researchers, you do not need copyright clearance if you incorporate the factual data in your own words in a structure owned by yourself, but you do need copyright clearance if you plan to share the secondary sources data for future reuse. So there is this, I have added a scenario. I would like you to read it quickly. And I don't think so that we have time left to go to Mentimeter. You can just add in the chat. After reading the scenarios, what do you think? Can the researcher use such public data without breaching copyright? Can the data be archived and shared with other researchers? What do you think? You can add it in the chat, which is quicker, I think, than the Mentimeter. Yeah, so no. No and yes, so mixed response. Yeah, it depends if they share a straight copy or process the data themselves. That's right. So yeah, even though the articles obtained are in the public domain, they are still under copyright, and such information can be used for personal research purposes, and but the articles cannot be archived unless permission is obtained from the newspaper. Otherwise, this would breach copyright. You can always check the terms and conditions that are mentioned on the different websites from where you take the sources. They always mention what you are allowed to do with the data and what you are not allowed to do with the data. And we will go through this in the copyright workshop in detail with real case studies. So we have done that in the chat. So if you are using secondary sources, then best practice is to assess who the copyright holder of the data set is. Are you allowed to use them, and in what way? Are you allowed to archive and publish them in a data repository? Because most of the time we encounter problems when researchers are allowed to use data as the data is under open license or they register to use it. What they do not realize is that it is not accessible to them for their use. Sorry, it is accessible to them for their use, but if they plan to share it, they do need permission to share it. So yeah, if the permission is not granted, then they need to remove the copyright material or the variables before publishing or sharing it for future use. So always best to ask these questions if you are using secondary data sources. So In order to be legally compliant, always investigate early which laws applies to your data, including cross-country collaborative working, and do not collect or keep personal or sensitive data if it is not essential to your research. And always plan early on, seek advice from your research office, ensure that you check participants know how this data will be used. And remember, not all research data are personal because anonymized data is not. And you can always get back to us for any sort of advice related to these. And I have added some links to the resources that could be useful for you on this slide. And that's it. I think you can register for the UK Data Service following this link or using QR code, and for the training events on this link. So there is no time for questions. I will administer your questions via Padlet. Keep an eye on that. I will do that after the workshop. And thank you very much.